So the bipartisan gun control bill was just signed into law by President Biden. This all comes in the wake of the recent Supreme Court Second Amendment ruling in Bruen. So let's talk about this bill and how it blatantly is unconstitutional under this recent Supreme Court ruling. But real quick before we jump into this video, if you think we don't need more gun control, go ahead and hit that like button and subscribe. Also want to give a shout out to one of the main sponsors of this channel, which is USCCA. Through your membership, you get training, education, and self-defense and liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. So like I said in the intro, Congress passed the Bipartisan Safer Communities Act, which we've discussed at length before here on the channel. Then it was sent to President Biden's desk, where he signed it into law. The House passed this bill on the same day that the Supreme Court issued their ruling in the New York State Rifle and Pistol Association v. Bruen, New York concealed carry case. In that decision, the Supreme Court struck down a May issue licensing scheme in the state of New York, but also reaffirmed the constitutional test that governments must meet to uphold their restrictions on firearms. This decision is already critical because of this new bill that was just signed into law. This bill passed by Congress, which was signed by President Biden, must meet this constitutional test established by the court. The test that the Supreme Court outlined in their recent ruling is text as informed by history and tradition. In the decision, Justice Thomas stated that, in keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearms regulations. Only if a firearms regulation is consistent with the nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command, and the unqualified command is shall not be infringed. So now that Congress has passed this new gun control bill, which restricts access to firearms along with other things, the government bears the burden of showing that their firearms regulations are consistent with our nation's history and tradition. If it isn't, then it needs to be struck down because it's invalid. Now, one of the first shortcomings of this bill is that it was framed and conceived of and built on an old concept, which is of public interest. The entire bill and bipartisan compromise rose out of the incidents in Uvalde and Buffalo. Congress claimed their whole goal with this was the public's interest, and that public interest was reducing shootings, so they passed this bill. Well, as the Supreme Court just held in Bruen, the government's interest, this public interest claim that they put forward for the reason why they created this bill, is now completely irrelevant. We no longer do a balancing of interests, which the government has relied on in the past. Instead, all that matters is the text, history, and tradition of the Second Amendment. So like I said, the very framework on which this bill was created is a violation of this recent ruling in Bruen. So now let's look into some more of the specifics in this bill that was signed into law and how those specific provisions will violate this ruling and violate the Second Amendment. Title II of the bill starts off by now making more people prohibited from being able to possess firearms by expanding the access to juvenile records and incidents that occurred while someone was a juvenile. This bill, however, goes on to also expand the background check process for anyone under the age of 21. Under this bill, the FBI can now delay a background check up to 10 business days if they want. Right now, the current laws are that if the FBI fails to respond to a background check within 3 days, the firearms dealer can release the firearm to the individual. This includes anyone under the age of 21. Under this bill, anyone under the age of 21 will now have to wait until the FBI responds to a check, and that can take up to 10 business days, which operatively could be way longer because 10 business days is 10 business days, it's not actual 10 days. So the question for these 18 to 20 restrictions which are included in this bill is first whether 18 to 20-year-olds have the right to keep and bear arms under the Second Amendment. Textually and historically, the answer to that is yes. 18 to 20-year-olds are part of the people contemplated in the text of the Second Amendment. 18 to 20-year-olds are considered to be adults. They can be married, they can enter into contracts, they can even go to war, and they can do a lot more. And also historically, they've always been considered to be part of the people. And that is because historically they were part of the militia, they were part of the subset of the people that joined the militia, and the militia was comprised of a lot of 18 to 20-year-olds, even younger than 18-year-olds sometimes, and those people were required, those young adults were required to actually bring their own firearms to service in the militia. It was a requirement. So then the next question is there any other historical regulation or analogs from the time of the ratification of the Second Amendment that justifies these types of restrictions? Well, historically, 18 to 20-year-olds were not picked out from the general class of the people and subjected to more firearms restrictions than just average people. Instead, 18 to 20-year-olds were treated just like any other adult and could purchase and possess like anyone else. So this section of the bill, which targets 18 to 20-year-olds and places restrictions on them beyond what the average person is not consistent with the text of the Second Amendment and has no historical basis. Because of that, this section of the bill is clearly invalid. But this bill does not end at just targeting people under the age of 21. The bill then goes on to include massive amounts of federal funding that will incentivize states to implement their own state-level red flag laws. This section of the bill says that states must respect due process and constitutional rights, but then includes various terms that allow states to completely ignore due process and other constitutional rights. For example, it says at a pre-enforcement hearing, people have the right to be represented by counsel, but the state does not have to provide counsel to them. So if you can't afford an attorney, one will not be provided to you under this bill. Also then says that the procedures and due process rights required for these types of hearings is only required when deemed necessary and appropriate at the appropriate time. This is another huge wiggle room language that the states get to use and apply and say, yes, we gave due process, but only when we thought it was necessary at the right time. So on this aspect of the bill, the question is, do red flag laws violate the Second Amendment? And are they subject to the text and history standards of the Second Amendment? This is one of those restrictions I think is pretty much an open and closed case. Under the text of the Second Amendment, you have a right to keep and bear arms. Red flag laws directly target your right to keep and bear arms, since if you are red flagged, you can't possess firearms. Then there's also the whole due process thing that brings up another question as well, but there is also the question if there is any historical analog for red flag laws as well. The answer to that is no. The government will have a really hard time arguing that during the founding, there was some sort of restriction that allowed the government to arbitrarily confiscate and bar people from possessing firearms. Even more so, they have to show that there was some sort of procedure that allowed the government and entities to come to someone's house without notice, without the correct procedures, and take property against their own will. That will be next to impossible to show, especially since that is what the British were doing, and that is why the whole Bill of Rights and the Constitution and all this stuff arose. It was because of the tyrannical actions of the British. So you can see how the text and history standards don't bode well for this bill or for the government, since their actions tend to be analogous more to the violations that we established the Second Amendment to protect against. Then there's a section of the bill that seeks to close the so-called boyfriend loophole. This section expands the prohibition on access to firearms to anyone in a dating relationship who has been convicted of a misdemeanor crime of domestic violence. The section defines the term dating relationship to be a relationship between individuals who have or have recently had a continuing serious relationship of romantic or intimate nature. Again, when looking at this section of the bill, you need to look at it using the Supreme Court's recent test of text as informed by history. And the text of the Second Amendment does protect your right to possess firearms, and a boyfriend loophole will target your right to possess. Then the question is there a history or a tradition during the ratification that supports someone that maybe you have a loose relationship with being able to use that relationship to bar your possession of a firearm? Again, that's going to be a very hard thing for the government to prove. They will have to show some type of law in 1791 during the ratification or around that time period that allowed someone with a loose relationship being able to go to an authority to have someone's firearms taken away and the possession rights being removed forever. That is going to be a very hard thing, if not impossible thing, for the government to show, because I'm not aware of any historical law or restriction that allowed a loose relationship to be able to do this. So that's what's included in this bill, and that is why pretty much all of it will fail under the recent Supreme Court ruling in Bruen. This may be one of the first national battles where we see the Supreme Court's ruling applied against the government. And it doesn't help the government's case that they passed it and signed it just a day after the court's ruling, and they did it in almost open defiance to that ruling. And you heard Biden and a lot of these other people in Congress saying that they were doing this and they were pushing this forward in direct response because of the Supreme Court's ruling. So we will definitely be keeping our eyes on this issue, but really I hope it gets challenged immediately. And I think under this recent ruling by Bruen and by the Supreme Court, I think this text as informed by history and tradition analysis does not help the government at all, because they have to find some sort of historical analog for these types of restrictions, which is very, very hard to do. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and it signals to YouTube that you guys see value in these videos and in this type of 2A news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And don't forget, the station was built by armed scholars, and the station will maintain armed scholars.